Something of that.
Proceed. Iya, dengan balik. Itu apa? Tapi itu konvensi. Bukan. Saya kumpul lagi. Kumpul itu. Bukan suara lagi ya.
Itu masih itu. Ya. Jadi sini.
Post cost,
My lord.
we take it along with the full bench matter.
My lord.
Lordship.
They will, what the statement? What the statement?
This on 12. I don't know, 12. My lord, on the 12th.
When is it, when is
On the
full bench
12th, my
matter
lord.
posted?
12th of March.
Full bench.
My lord.
Lordship.
Sure, no?
Yes, sir.
12th of March. Yes, yes, I'll be here. The matter is taken up for hearing. It is represented by the petitioner that this public interest litigation is connected with the batch of cases that is pending before the full bench. The counsel appearing for the respondent would submit that it is not a public interest litigation and is only the private litigation is tried to be espoused as a public interest litigation, and that the maintainability of the petition, writ petition itself is questioned, PLS is questioned. The counsel appearing for the respondent also admits that similar points have not been raised in the subject matter pending before the full bench. So, in order to give a quietus to the matter, we are inclined to take up this matter along with the other batch of matter pending before the full bench. It is represented that the full bench matter is posted on 12th. The registry is directed to list this matter, so and so. We also make it very clear that in case we accept the plea of the respondent, that is only private interest litigation, cost will be imposed on the petitioner.
Pleasure.
Post on 12th.
Item number 7.
Delay.
But this is central excise appeal, my lord.
Delay.
Central excise appeal against the order passed by the tribunal, my lord. My lord, the notice
Coming up for first time.
first time, my lord. The notice has to.
Notice will have to go.
My lord.
Notice, private notice. Notice also permitted on the counsel who appear in the writ petition.
My lord, this is from tribunal.
Director,
Well.
central excise, yes, bench, before the bench,
My lord.
yes.
This is notice for registered post, my lord.
Huh? Yes.
Registered post.
Notice, private notice, returnable by first week of April. Give the date, madam, so that it will be easy for them to send a private notice.
Item number 8.
Well, this is an appeal delay of 183 days, my lord, in preparing appeal.
183 days,
183.
delay condoned. Respondent has no objection, delay condoned. Yes. This is that, list the matter for admission next week.
Item number 9.
Common judgment, my lord. See.
Same,
Same, my
delay.
lord, 183 days.
This is a POCSO,
POCSO, my lord. But conviction under 376D.
under
376D, my lord.
376D.
Life imprisonment.
Item number 10.
Obligation.
May I please, your lordship. My lord, this is a so moto PIL, my lord. The issue involved here is the expansion of the Omroi airport, my lord.
Last time the matter came with them.
Yes, my lord. There's two matter, my lord. One is the expansion matter and the another one is a compensation matter, my lord. Last time when it came was the compensation matter, which is coming on Thursday. So today is regarding to the expansion.
Both will have to be heard.
Separately, my lord, was segregated separately because one pertains to the compensation and that has come back from the Supreme Court requesting the Honorable Chief Justice of this court to appoint a district judge to inquire into two allegations.
But remember that the first inquiry was not conducted properly, and second time it was done.
Yes, my lord. Now the reports are there.
That is a different case.
Yeah, that's a different case. That's
Because I was wondering, when I was reading the paper, then my PA said, this is not the matter, but I found that there are two matters.
Yes, my lord, there are two matters. So, my lord, so this matter 2015, what happened was, so moto was taken because the citizens of Meghalaya was suffering because we do not have a big connectivity, regular connectivity. So it was taken up so that facilitate for big aircrafts like Boeing 320, 321 to land here. Only now the ATR is functioning, but with the intervention of the
But is
court,
there any land available for expansion?
my lord, that is now my lord.
Land is available, my land is not an issue, my lord. What is creating problem is, my lord, there are hills on the both sides of the runway, my lord.
Sir?
There are hills on the both sides of the runway. So if you expand the runway, my lord, the hilltop come on the trajectory of the flying trajectory, my lord. So, my lord, for that purpose, because earlier survey was done, but now with this sponsored by the state government, my lord, they paid us 4 crore rupees for doing LIDAR survey, my lord. That is called LIDAR.
But at present only ATR is
At present, only ATRs
Flying.
can fly from here. Because the length of the runway is about 1700 meters, my lord. And length of the runway is about 1700 meters, 1.7 kilometers. For larger aircraft, the minimum required is 2.2 kilometers, my lord.
so it's not possible for you to expand for 2.2.
So, my lord, what we have done now,
Huh?
what we have done, my lord, if Lordship kindly sees my affidavit dated 27th of February, my lord.
Is that one?
Yes.
Well, para 2, my lord, para 2 and 3.
Para 2 of your affidavit.
My lord.
Yes.
That this honorable court, by the order dated 2/2/24, passed in the instant case, was pleased to direct Airports Authority of India to file an affidavit bringing on record the latest development as regards the proposed.
I think this is the case where somebody was asked to be present and the matter went to the Supreme Court. Supreme Court, they don't insist the presence. Is this the case?
No, my lord. This is
not this matter, my lord.
Some order was there. Huh?
that one. Maybe it is a compensation matter, my lord. I think.
Well, here, what is the case?
Because there is one RTP, once SLP order is here, especially petition Registrar General of High Court of Meghalaya have taken on board, heard both the parties, exemption for certificate of issue notice form. So until further orders or order of personal appearance before the High Court shall remain stayed. It's an order of the Supreme Court dated 13/12/2018.
My lord, at that point of time, my lord, maybe some official of Indigo Airline was summoned, my lord.
Oh yes, my lord. That is.
So Jet Airways was there.
Jet Airways.
Yes, my lord. But that is gone, my lord. That is.
So that part is over now for the time being.
No, who is going to, now only Indigo is alone there.
Indigo or Air India, my lord, and SpiceJet also.
Why don't you ask them to appear on the screen? So we'll ask them what is the feasibility.
My lord, they will not be able to say because until
No, the person who is for laying the runway will be a huge techno-savvy person must be there, is it not?
So, my lord, for
How it
that
should be done?
My lord, for that purpose, a survey is required, my lord. If Lordship kindly sees my affidavit, my lord, we have stated here.
Yes. Later they will got a proposed topography of also aerial detection.
So, my lord, this is a survey that is conducted with drone and aircraft, my lord,
Yes.
to see the topography, where is the feasibility of extending the runway, my lord. And for this purpose, because the airport authority do not have facility for this, my lord, we have issued a tender, my lord. Lordship will kindly see at page 5. We have issued an open tender. Now, tender, your lordship will see at page 12, my lord.
Tender document, yes.
Name of work, topographic and OLS survey by area leader at Shillong Airport. So, my lord, as of now, my lord, we have received 4 tenders against this NIT, my lord, and we are scrutinizing those tenders. And once the tenders are finalized, we will award this survey work to one of the contractors, my lord. So, we are at that.
So this is only for the purpose of survey.
Only for the purpose of survey, whether it is possible or not, my lord.
For the purpose of survey, what is the amount?
4 crore rupees.
4 crores.
Because this is done with the drones, my lord, and with an aircraft, my lord. So, my lord, within next 10 days, we are expecting that we will be able to award the contract, my lord, to finalize the tender and award the contract for this survey, my lord. So once this report comes, my lord, OLS report, then we will be able to take a final decision.
We'll wait for 10 more days.
My lord, but we'll wait for 10 more days, my lord. But kindly note this point, my lord. 2015, when the full bench of this court, because on the assurance of the airport's authority, they said yes, Boeing landing is possible. Therefore, this full bench directed, go ahead. Then suddenly what
I do
happens?
not know. See,
Yes.
my brother also said probably this may be for the purpose of compensation.
My lord,
The person's of appearance of the person.
my lord.
But what we are of the view now is that if the persons appear before us,
Yes, my lord.
we will also have a view
My lord.
as to how it can be done.
My lord, the airline operators, my lord, they will not be able to throw much light on this, my lord.
Why?
Because this is basically the work of the airport authority, my lord. They have to see how much.
No, we will discuss with the airport authority, not only airlines. We will also talk to the airport authority because they are the parties. The pilot will know whether it's feasible or not.
My lord, I don't think pilot will know much about this, my lord.
So unless the runway is long, you can't expect a larger aircraft to
Land at a shorter.
land at the short place.
My lord.
It will be a problem.
My lord. Well, that is where, my lord, we are studying the feasibility, which side the runway, if at all, can be extended, my lord, to make it suitable for a landing of larger aircraft, my lord. And for that, the only survey that is required, my lord, is the OLS survey. The OLS survey will be able to tell us exactly, my lord, whether it is possible or not, my lord. They'll measure the height of the hills also, my lord. They'll measure the terrain. They'll measure everything and give us a report, my lord.
Because earlier what happened was, my lord, too much money, government's money has gone here, and still the objective has not achieved. 2 hills were already chopped off, my lord.
Sometimes the persons in Guwahati may not like to have an airport here.
Exactly.
So this is the effect.
My lord, that is not the case, my lord, now. Because government is all out, my lord. The policy of the government is to create more and more infrastructure, my lord. Because of this pendency of this PIL, my lord, today, my lord, because earlier till 2015, this runway, there was no aircraft flying from this, my lord. Now at least we are having 7 to 8 regular flights every day, my lord. And entire north is connected with Shillong now, my lord. But the only problem is that what can be covered or connected through ATR airlines.
In some places, it is not good. I think there will be direct flight from Calcutta to Shillong.
My lord,
But from Shillong, it is not going to a particular place every day.
Yes.
yes, my lord.
Delhi, they have started, my lord, in a week.
Different places.
Because to fly to Delhi or to Bangalore or to Chennai, my lord, will require larger aircrafts. The ATRs cannot fly from Shillong directly.
Yes, that is right.
Because their fuel tank capacity is less, my lord. And there are other issues also, my lord.
Why not we inspect?
My lord, you're also most welcome anytime, my lord.
Because there are precedents saying that the sitting judges can do that.
Yes, my lord. The airport manager is here, my lord. We can fix any date, my lord.
In the meantime, you award tender within 10 days.
My lord.
We'll also try to, within 10 days,
My lord.
we'll try to go and see the place.
My lord.
We'll also have an idea about it.
This is the airport manager, my lord, Shillong Airport. Airport director. Airport
We
director.
want a technical person to be present so that we'll have an idea about it. Right. See, we cannot have airport for the sake of airport.
Right.
Runway should be there and it should be safe for the passengers.
Right.
That's very important.
My lord.
Including the life of the pilot is also important.
My lord.
Very important. So, let the technical person also be present. We'll have an inspection. We'll see whether any feasibility is there. So we'll have, this is possible, that is possible. We'll also put our questions. We'll have an idea.
My lord, but date and time is fixed for visit, my lord. They'll arrange the technical people also, my lord, on that day.
We'll have an idea about it. You can also be present.
My lord, my lord.
Tomorrow is not possible. Day after tomorrow, I'm going Thursday. Is it possible tomorrow?
Sir, I may have to call some expert from the regional headquarters or maybe the actual corporate headquarters.
How long will it take? Week's time?
Maybe
A week's time, my lord, is
a week's
requested.
time will be okay.
We'll have it on 12th.
Well,
My lord is looking at April, that's March.
12th is a Tuesday. 12th is okay.
12th.
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 But I have another engagement on April 12th, maybe
11th or
11th, maybe
11th or 13th.
11 not possible.
13th.
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 Right.
Well, when the matter is taken for hearing, it is represented by the petitioner that the issue is pending from 2015 and that even after the orders of the Supreme Court, no finality has been attained. The counsel appearing with the respondent would submit that tender has been floated and that in another 10 days' time, the tender would be finalized. The airport manager was also present here. Give his name. So also present. Both parties submitted that we can, the judges can see the airport to ascertain the topography and that the technical person will also be available to explain the pros and cons of expanding the airport.
Well,
Mr. The general manager who was present would submit that he'll ensure that the technical person will be available on 13th afternoon to enable us to be present for inspection along with the counsel appearing for the petitioner and the respondent. Oh, yes, amicus. Amicus, yes. Sorry, amicus, sir, not petitioner. Amicus.
only the tender process will go ahead, my lord.
Yes, we are not saying anything. You go ahead with the tender process.
Well.
We will have a broad idea,
Well.
if possible or not. So based on that, we can also ask questions.
Well, they'll be ready with the petition.
Ultimately, the national interest and the expansion of tourists, ultimately this place is tourist attraction. And that unless you develop the free flow of aircrafts, the person may not come.
It's true.
When the roads are under. Sir, date is 13th. Date when they give it a. Yes, postman.
My lord, some
Inspector
state
order.
government Some state governments were also represented, my lord, on that day.
And any other person who is interested can be, the council can appear. Not that the entire village should come.
My lord.
Apply.
Item
The
11.
person who come must give us a good input.
Somebody from the
Rather
PWD,
than,
so far state is concerned, Your Honor, somebody from the PWD may be
yes.
Or transport of it.
transport. Anybody.
Who are all, give the names who are all going to become, so we can record it in the order.
My lord.
Give the names of PW engineer or somebody who is going to be there.
What, whom do you?
Whom do you want?
PWD, one from transport, I think.
One from PWD and one from transport.
One from PWD,
And one from transportation.
transport. Yes.
DP.
Apply, George.
We will call the matter after 2 weeks, but we'll do the inspection on 13th.
Worship.
Item 11.
Yeah, please, Your Lordship.
See, both the judgment of the Madras High Court affirmed by the Supreme Court, Order 18, Rule 18, that you could quote the judgment. Yes.
My lord, this PIL pertains to the deplorable condition of road in the East Gentiles.
Connectors?
My lord, in the East Gentiles, my lord, deplorable condition of road, my lord, road. NH6, my lord. If my lord, can you come to last order?
1 minute, sir.
Lordship, can kindly go through the last order, 8 February. It will set into a motion for the requirement of today.
Yes. Yes, this is with regard to the vehicle movement.
Lordship.
Lordship, I represent the National Highway, my lord. My lord, I have filed a small affidavit dated 27th of February, my lord, and we have given a status report of what are the steps taken by the National Highway to ensure that the roads are repaired and constructed, my lord. This is by the Project Director, National Highway Authorities of India. Page 4 onwards is my
This
status
is the-
report.
This order, oh, this is affidavit,
Yes, my lord.
dated
Affidavit
26th
dated-
February,
Yes, my lord.
3 paragraphs.
My lord, in fact, the detailed response is given in the status report, my lord. That is why the affidavit is short.
Where is the status report?
Page 4 onwards, my lord.
Oh, yes, sir.
So the detailed affidavit is given on behalf of the National Highway Authorities on status report, my lord. My lord, there are temporary measures being taken, my lord, for pothole repairing and filling up, my lord. But for the strengthening of the overall road, my lord, 2 contractors have been allotted with the contract work, who are due to start their work by the 4th week of March, my lord. My lord, this will take some time for the overall strengthening of the road because.
How long will it take?
My lord, the time period which is given to the contractor is 1 year, but then we will put pressure on the contractors to ensure that the roads are strengthened at the earliest, maybe by another
6 months.
5-6 months, my lord. Because 102 kilometers and 2 contractors have been allotted with the standard, my lord. And it will
What do you say, sir?
On the last occasion, my lord, there were two stretches, my lord, which were in bad, two stretches, my lord, which were in bad condition, my lord. And in fact, in the affidavit which they have filed, I have just received the copy, I've received on 27, my lord. We'll have to examine that aspect, my lord, because here they stated that, my lord,
See, now that they have appointed, they have given work to two contractors for strengthening the place.
my lord, may kindly,
What will happen? The bridge will collapse.
at least, my lord, temporary arrangement.
You and I will float in the water.
Absolutely. But my lord, at least as a temporary arrangement, my lord, those potholes, big potholes which are lying on the road.
Big
it is
potholes?
That would be, yes, my lord. It is
They
that
said
would
they
be,
will do it. They will strengthen the road.
We are doing it, my lord.
but here,
So
my
you
lord,
must give time for that, for curing everything.
my lord, this contract tender, my lord, this issue,
Sir,
my lord.
now they said that one Dar construction company and another company has already been given work and they're going to start in 4th week. They want 5 to 6 months. We'll give 5 months time. They said it will take 1 year time.
Even for finalization, my lord, they will take time. At least unless, my lord, this honorable court issues proper directions.
No, they're going to start the work. The work has already been, they're going to commence the work, already awarded.
Because for repairing work also, my lord, it took
Sir,
them quite
if there
some
is
time.
any problem, it is open to you to mention and bring the matter. We'll record it. But we must give them some time.
Lordship.
See, if you see, wherever I see, underneath, the water is flowing. Do you know swimming? Do you know swimming?
Little bit, Lordship.
I don't know swimming.
Little bit.
My lord, there is one more major portion, my lord, where the frequent landslide occurs the moment there is some rain, my lord, which is in the Sonapur tunnel. For there also, my lord, we have given.
Sir, you want 5 months time
Yes, my lord.
to carry out the repair work
Yes,
and
my
ensure that the strengthening of the places and all strengthening of the road and also ensure that the potholes are filled and the road is ensured that
Yes,
it is
ma'am.
fit for traffic. We'll record this. And if there is any problem, you mention it. We'll give you liberty.
My lord. At least, my lord, till they finalize repairing works and my lord, filling the potholes may kindly be completed, my lord. Because, my lord,
Measures are going on.
these, my lord, since the day this petition have been filed, my lord, they have been making assurances and, my lord, finalizing contracts, it has been taking time.
It's an ongoing process, my lord.
Everything has got a time limit, sir. Everything has got time period. Though we know that they are taking time and time is, the procrastination is there, all those things will be there. But the necessary period will have to be given to ensure the proper pillars are put and bridges, strengthened. Otherwise it will be very difficult. Fortunately, here there is no public transport. If you have public transport, an entire road will become very bad. You must see the public transport in Tamil Nadu. They will travel in footboat. Only 40 to 50 passengers can go in the bus. 100 will be traveling. Yes. Pursuant to the orders of this court, dated 8th February 2022, 24, an affidavit and status report have been filed by the respondent. According to the respondent, Jawai Ratachera section in National Highway 606 to an extent of 102.255 kilometer is being attended for repair works, and that contract have been entrusted, the two contractors have been identified, namely MR Construction and Dar Construction Company, and that the work is going to commence for the purpose of strengthening the road and the potholes are attended to. Full stop. He would further submit, respondent would submit that, respondent submitted that unless the stretch of the road is being strengthened, it may create further damage to the road and the bridge, as referred to in the status report dated 26th February 2024. And he also stated that while attending to the repair work on account of deterioration of the road, the respondent must ensure that none is affected and that the pipelines is said to pose threat to the passengers and pedestrians are also attended to. Full stop. Further stated that there is no leakage in the hazardous pipeline while strengthening the road. Full stop. The respondent would submit that it would take at least an year for the repair work as mentioned in the status report to be carried out, and stated that they will ensure that the work is completed within a period of 5 to 6 months. Stop. The counsel for the petition would submit that the matter is pending for a long time and that unless the work is carried out at the earliest point of time, it will be very difficult for the citizen to commute. Full stop. Though the respondent has stated that they require an year time, though stated that they require and the contractor require an year time to complete the work, they will ensure that the work is completed within a period of less than 6 months. Less than 5 to 6 months. In order to ascertain the progress, we direct the registry to list the matter during the last week of August 2024. In the meantime, in case of any exigency or emergency, it is open to the petitioner to mention the matter after giving due notice to the respondent. How many contractors? 2 or 4?
2 contractors, my lord.
What is the name?
The Purvanchal,
Huh?
my lord.
First one is Mrs. Purvanchal.
Not the MR construction.
No, my lord.
No, yes. So not MR construction. The original given.
Originally.
Yes. Sir, his name is Prabhuchal. Prabhuchal. It is in page number 4
Yes, my lord.
of page number 67. Sir. Page number 67. Inner page 4 of the status report. It's at para number 2.2, the name. The other one is in para number 5.1.
3.2.
Yes, 2.2. Both names are there.
In fact, Lordship, if you see today's Shillong Times, the National Highway Authority of India has informed that almost 15,000 crore has been sanctioned for a super highway from Umiam, Rachetera to Panchgram, same road. It is there in the headlines today, Lordship.
Sir,
As per today's Shillong Times report, Lordship, the National Highway Authority of India, NHIDCL, has informed that 15,000 crore has been sanctioned to strengthen the bypass which connects Umiam to the Rachetera and it goes to Panchgram in Assam.
good.
So it's there in the headline, Lordship.
But sad thing, my lord, is the money has been sanctioned, but ground reality is totally different, my lord.
We'll see what is going to happen.
We'll come with this.
Western bypass, as per the report, for the Western bypass, 630 crore has been given to the state government. That connects Umiam through West Khasias. This is a slight development that happened today.
See, you must understand this is not plain. This is, hills.
Lordship,
You
absolutely.
must have a proper, way to find out how it should be connected. That's very important.
NHIDCL is the
Initially, everybody went by foot,
Lordship.
then bullock cart,
Yes.
then horse,
Oh,
then elephant, then cycle, bicycle, motorcycle. Then now it's Jaguar. Oh, it took time. Similarly, we'll see. Yes.
Item 12.
May I please, Lordship?
Yes, sir.
Lordship, these matters pertain to whether GST will be applicable on royalty. In a similar such matter, your Lordship has passed an order on 28th of February, wherein Lordship adjourned the matter sine die because the Supreme Court royalty matter is pending before a 9-judge bench. Lordship had granted liberty.
Yes. Grant liberty. But the matter was adjourned sine die.
Yes.
yes, man.
Huh?
Lordship,
When is
Lordship.
you
Lordship.
answer,
Because
take
Supreme
the order
Court,
and type it.
9-judge bench is hearing the matter, man. The hearing is commenced in the Supreme Court. Man.
As we said, post it immediately after disposal. Sir.
Mine.
Yeah, take that order and type the same order. Yes.
Item number 13.
Item 13.
Here I appear as a amicus, my lord, but I am required to file an affidavit. I am paying for some more time, my lord, in this. This is pertaining to crematorium for the indigenous people, my lord, in Meghalaya.
The state had filed a detailed affidavit, Lordship, and then the amicus.
From Java Hills, I found some people are burying the bodies on some place, and ultimately it has become a cremation ground. Burial ground.
My lord, burial grounds are there, my lord. The cremation ground,
Burial ground. No, burial, not cremation ground, burial ground.
Burial ground.
So, law. I said, how it's come, the opposite is the house. There are houses.
my lord.
This side of the road, houses, that side is a
Burial ground.
From Java Hills to Shillong, I saw that. I was wondering how is it.
I'm praying for 3 weeks or 4 weeks time. My lord.
What's the matter? At the request of the petitioner, what's the matter? The first week of April.
Well, deeply.
Item number 14 and 15.
Two matters. I think there's an entire bag is there, no? 14, 16, 17, 18.
16 to 21.
That's also review.
My lord, these are applications for condonation of delay in filing review, my lord.
Delay?
Delay of 773 days, my lord. My lord, so primarily, we file an SLP against the order passed by this honorable court, my lord. And I've quoted the order, my lord, at page 3 of the application, lordship kindly sees, my lord.
Page number 3 of the affidavit.
Of the application, my lord. page 3 of my application.
How is the review maintainable? Where is the error of law?
My lord, we have come, my lord.
47.
My lord, the error of law, my lord. Well, here what I happened, my lord. In Northeast, my lord, there is an industrial policy which provides for excise duty exemption for certain number of years, my lord. So any new industry set up in Northeast, my lord, under the industrial policy of the central government, were entitled to central excise exemption, my lord. Now what, and there are certain prerequisites for that, my lord. Being that the industrial unit should be a new industrial unit, my lord. They should have a proper plant and machinery.
Where is the order of this court, which is under review?
My lord, that is annexed with the review petition, my lord. If the review petition is with your lordship, okay.
(23/9, 2021).
My lord.
Is that order?
This is the order, my lord.
Connection A1. Check.
Yes, my lord.
This is a under
We
review.
are seeking review of, my lord.
Where is your prayer for reviewing?
Page 32, my lord.
Let's see.
32.
(23/9, 2021).
My lord. But as praying, my lord, lordship kindly condone the delay today, my lord.
No, not required, because in the light of the judgment of Supreme Court, the review petition will have to be heard by very same bench, or one of us should be in the bench.
Yes.
So order passed by yesterday. So thank you. That's right. So he should be part of the bench.
My
My lord, the prima facie, this case is not maintainable under who is.
That is right. No, no purpose is going to be served if you argue now.
Yes.
You have to hear, because there is judgment of Supreme Court. You should have brought to our attention.
That is there. So one of the.
When the bail is rejected,
Yes.
the bail matter will have to go before the very same judge.
Same judge.
Similarly, in the review also, it should go before the very same bench, unless the judge recuses or both of them are not available on account of elevation, transfer, retirement, etc. Yes. Register is directly listed before the bench consisting of so Chief Justice and Justice. Thank you.
I'm deeply.
Item number
Next
16.
week. We'll post it next week.
Next week. Okay.
Item number 16. 16 to 21.
Take out the judgment, read one of my judgment on the Madras High Court.
Yes.
I have considered all the judgments of the Supreme Court with regard to review.
Yes, my lord. I have seen this judgment.
The earliest order was passed by me in 2018, sitting with Justice Venugopal.
Yes.
And thereafter, the subsequent judgments have also been.
Yes.
Item 16 to 21.
Item 16.
There are similar matters, Your Lordship, arising out of the common judgment.
Review.
No, not review, it's an appeal, Your Lordship, wrote appeal.
Lordships will recall, my Lordship, that states were directed on the last occasion to obtain instruction as to the proposal of reinstatement of the petitioners in the
Your Lordship,
service. That was before I opened my case, my Lord.
What was the suggestion made by the court last time?
My Lord, yes. States were directed to obtain instruction as to the proposal of reinstatement of the petitioners without back wages.
No.
You are agreeable?
I don't know, my Lord. That was the instruction, my Lord. So before I open my case, my Lord,
Your
just to
Lordship,
remind.
the matter is delayed, the writ appeals are delayed.
Now you are concerned about the delay.
Delay, let us finish this, Your Lordship, and I may be given a patient hearing, Your Lordship, then Your Lordship can pass any orders, Your Lordship.
Do you have any objection with regard to the delay?
Your Lordship, even the grounds given in the delay are not sufficient grounds, Your Lordship.
No, grounds different. Now with regard, now you are concerned about the delay.
The grounds for the delay, Your Lordship.
Also delay, yes.
Grounds for the delay, they have given, there is a delay of 109 days, Your Lordship. And their contention is that because Mairang is a very remote village, which is actually not, Your Lordship, and that there was no means of communication with the clients, so they could not file the appeal on time. And such, there was a delay of 109 days, Your Lordship. So my contention is that, Your Lordship, the grounds given by them are not sufficient or cogent grounds for combination of the delay, and that the application may be rejected, Your Lordship.
Petition has come forward with the present unknown to delay. The main reason given in the affidavit was that the petitioner is residing in a remote village, so and so place, and on account of non-availability of internet, the petitioner could not communicate with the counsel for preferring the appeal. So, the respondent would submit the reason given by the petitioner is not germane, and that delay is not properly explained. Stop. The taking note of the fact that the petitioner is living in a village and that they belong to a tribal community, that there is a possibility of non-communication to the counsel to prefer an appeal. No prejudice is going to be caused to the respondent if the delay is condoned and the matter is taken up on appeal. Delay is condoned, matter is taken up for hearing on minutes. You quote the judgment of the Supreme Court. Delay condoned. All 109 days.
All 109.
All cases.
All 109 days, Your Lordship. And Your Lordship, the last occasion, service had not been effected in respect of item number 18, Your Lordship. Miscase 27 on the private respondent. On the last occasion, Your Lordship, the petitioners, the appellants had stated that service had not yet been effected on the private respondent, and they had sought time to take further steps.
My lord,
Whether that service has been effected or not, we are not aware.
my lord, this is a case, my lord. Why this services, my lord, is coming into issue, my lord. Yeah, my lord, one of the
Have
ground,
you taken steps?
I have taken, my lord.
Where is the proof?
My lord, I'm here to,
Yet to get the acknowledgement.
my lord,
Insofar as item number
3, man.
Item number 18, Your Lordship,
18.
which is
With
18.
regard to other cases, delay control, where parties are served. With regard to 18, post after service.
My lord, yes.
See, when the private respondents are there, they have to be served.
My lord, yes. We have taken these steps.
How?
In one case, the same, it is the same private respondent. In that case, it has been
Who
served.
appeared for the private respondent in the writ petition?
My lord, no one appeared in the first round of litigation.
So they said ex parte.
My lord.
They have said ex parte.
My lord.
Yes, I think the one judgment of Supreme Court, even if they are set ex parte in the original round of litigation, subsequently also you will have to send notice. That's the reason.
My lord, yes. We'll file affidavit of, my lord, issuance.
Right. Otherwise, if the change of address or postal cover is returned, person not known, change of address.
My lord, in this case, there was,
affect paper publication.
in this case, my lord, private respondent was transferred from one department to another department, my lord. That's why
Where is he working? He or she?
he, my lord.
Where is he working?
Presently, my lord, in West Castles, my lord.
So he is working under you.
My lord.
He's no longer working with us.
No longer working under you.
As far as my instructions are there, Your Lordship, he's no.
He is not at all
He's
working.
returned unserved, incomplete address. That was the.
No. Whether that person is working or not.
He was working under me, Your Lordship, but I am not aware if he's still working with me, Your Lordship.
If he's working, you can serve the papers.
If I'm not aware, Your Lordship, because this private.
Can you give the details of the person where he is working?
My lord, yes.
Give to the respondent.
My lord.
Let him take steps, Your Lordship, because in one case, the private respondent, the same private respondent, it has been served in this appeal. In another of the appeal where he is the same private respondent. But in this appeal, it has not been served.
But it's a connected batch. If he's working, he has to receive your letter. He can't say any official communication given by you be refused.
Because I'm not aware if he's still with me. Anyway, we'll try, Your Lordship. If it's there, we'll try. Otherwise, we can also take
If the
steps in
petitioner
that
is able
regard.
to give the details of the place of employment, present employment under the respondent, the same may be intimated to the counsel for the respondent, and the counsel for the respondent shall ensure that the said respondent is served through the office.
My lord.
Mentioning the date of hearing as, give the date, specific date in the month of April.
Deeply obliged.
Item 20,
22, 21 are similar matters. Your Lordship.
item 22.
Oh, sorry. Oblige, Your Lordship.
It please your lordship. Lordship, in terms of your lordship's last order, but we were required to file some affidavit, my lord.
Sir?
We were required to file an affidavit, my lord, bring on records all the orders which has,
You want to file an affidavit for?
my lord, to bring on records the subsequent orders, my lord, which have passed in this particular case by the, my lord, the respondents.
What is it?
My
The
lord,
order
we kindly have the order dated
on
7.
the Income Tax Act.
Yes, my lord.
What is it? Escape assessment?
It is, my lord, we are challenging the demand notice which was served on us by the respondent authorities, my lord, in spite of the fact that I'm.
Challenging demand notice.
Yes, my lord.
Then how is it
Also the
represented?
assessment, also the assessment order, my lord.
Also the,
Assessment order, my lord.
don't you have a right of appeal?
We have, my lord. It has been.
I think you
in
now
fact-
deposit some amount and then you have to
in fact,
prefer
we have-
appeal, no?
preferred an
How
appeal
much?
also.
25% or
It's 20%.
20%, Lordship.
20%? Oh.
But in,
Sir, when you have an alternate remedy, how can you approach this court, sir? Challenging that order?
Malad, subsequent to that, Malad, there was a substantial Malad, delay in taking up the proceeding. Malad. That's why we were approached this honorable court.
No. When you have an alternate remedy,
That has been exhausted, Malad. Of
will
course,
give you
we will
liberty to approach the authority concerned. Go and approach the authority. Where is the order? Which is under challenge?
Malad, your lordship will find the 3 different orders. The last order, Malad, will find at page 32.
Page number 32.
Yes.
This is a demand notice. You say that if there is any matter is pending, you pay 20% of the amount. If you have agreed, you have to file an appeal.
Malad, the appeal,
One of the
instructed,
present
Malad,
petition has been filed, challenging the order date so and so and so and so.
lordship,
Admitted
Small
that the
indulgence,
petitioner has got a right of appeal in terms of the provisions of the Income Tax Act, questioning the demand without recourse to the alternate remedy is not permissible. Then without rendering finding on the merits of the matter and giving liberty to the petitioner to approach the appropriate authority under the provisions of the Income Tax Act, this petition is disposed of. If the time to be prescribed in the Act is already expired, 30 days time is given to enable them to prefer an appeal,
Malad,
and the authority concerned is expected to pause orders within a period of 3 months from the date of register of the said appeal for representation, after affording opportunity to the parties concerned.
Malad, I'm sorry, Malad, I could not interject in between, Malad.
Huh?
Since your lordship was passing the order, I could not interject. Malad, here the appeal has already been filed, Malad, and it is pending, Malad. Only difficulty.
Appeal is pending.
Yes, lordship. Only thing, Malad, if I may come tomorrow, Malad, with this instruction, Malad, whether we are to pursue the Malad, appellate authority.
Then you let the appellate authority pass an order. That's all.
Kindly grant me a day's time, Malad. I'll take instruction on this.
No, it's not required. When the matter is taken up for hearing, change the order. The matter is taken for hearing to represent that against the order impugned in the writ petition, appeal has already been pending and the appellate authority is yet to dispose of the same. Full stop. The parallel proceedings is not permissible, and the petitioner cannot be permitted to ride 2 horses at the same time. Hence, giving liberty to the petitioner to write all the objections, factual and legal, available to him before the appellate authority, the writ petition is disposed of without rendering any finding on the merits of the matter. The appeal is expected to be decided by the appellate authority within a period of 3 months from the date of register of the order, after affording an opportunity of being heard.
Malad, kindly, no course of action may be taken until such time the appeal is disposed.
They will not take. How will they do it? When the appeal is pending, only after appeal is they will do it.
Appeal is pending, Lordship, so no question.
They will not take any coercive action.
At times, Malad, they go to that extent.
No. See, there is a condition precedent that you will not deposit 20%. If you deposit what, no action will be taken. You can't say, I will not deposit the amount, no action should be taken. In fact, appeal itself will not be maintainable if you don't deposit.
Good.
I'll have Lordship.
Yes.
Item 23,
Item 23. Really, so much matter.
My lords, in this matter, I have received some instructions from the department, my lord. However, my lord, it will be necessary, my lord, if the same is brought on record by way of an affidavit. My lord, it will be necessary, my lord, if the same is brought on record by way of an affidavit, my lord.
When will you do it?
Lord, I'll pray for 2 weeks' time, my lord.
What's the matter? Next, on the request of the respondent, what's the matter? Today is Wednesday.
My lord.
Yes. Who's on Wednesday? Wednesday.
My lord. My lord, I am praying for 2 weeks, my lord.
You asked for 1 week.
My lord, I
He already has instructions, my lord. I think 1 week.
my lord,
suffice.
because a lot of instructions I received, my lord. So I have received a lot of instructions, my lord. I want to file it properly, my lord. So if kindly 2 weeks' time, my
You
lord.
want to contest the matter?
Yes, my lord.
I think hereafter I should not open my mouth. I have to listen and then pass out this. Sometimes, try to mediate and settle the matter gives rise to lot of paper book.
My lord, some difficulties are there, my lord. So that is what we want to.
Yeah, they're not
Apprise the
compassionate
honorable
enough, my
court.
lord. The problem is that they're not compassionate enough. They do not understand the plight of a great.
No, that's not the
I
case.
think this is a case where the compassion appointment was given.
No,
There
that's
were
not the case.
seniority
This is where
No,
I've
that's not the
worked for
case.
This
more than 30 years, my lord. They contend that I've worked as a part-time employee. And Lordship on the last.
She was working from
My lord.
1991.
1991, my lord.
Yes.
But there's no compassion on their part. My lord. They still want to contest. They don't want to give me anything, which I am very much entitled to. Lordship has already heard the matter.
You will have to carry out this instruction. You will have to argue.
Yes, my lord.
You can't compel the party to settle the matter.
My lord.
My lord.
If anybody is agreed, let them challenge it.
My lord.
I think when I feel that the parties have a particular favorable order can be passed, I think I should not suggest for any settlement.
That's not the case, my lord. But here,
Well, they want to file
difficulties
an
are,
affidavit.
my lord, that's not the case.
Weeks time.
Difficulties are genuine, my lord. Difficulties are genuine.
See, you must
My
understand, a
difficulties are
person is
genuine,
working from 1991.
My lord.
He cannot be a part-time employee for 30 years.
My lord will kindly see.
Such
My
policy
lord
of
will
the state,
kindly, my lord will kindly examine the other aspect also, my lord. The writ petition is filed in 2019, my lord.
There's a delay.
There is a delay, my lord.
Look, I have been, if Lordship, I find
There's a
public.
delay.
Yes.
To that extent, we'll mount a relief.
No, lord, some genuine difficulties are there, my lord. My lord, I may be allowed to place it on record before this honorable court, my lord.
Is she drawing, is still working?
She's still working, my lord.
So,
My lord, the additional
no,
benefit.
you fix the pay, don't pay any difference in arrears.
No, my lord, because there's a long queue, my lord. It will unsettle a lot of things, my lord.
That is your fault. How can you engage a temporary employee for years together? Where she got employment in 1991.
91, my lord.
No, my lord. 1991, that is not substantiated with anything, my lord.
They have their own
So
documents.
when did she join according to you?
According to our document, my lord, she joined in 93.
90?
93, my lord.
93. Okay, 2 years different.
As a part-time,
93.
my lord.
Supreme Court has categorically criticized appointment through back doors. You will have to advertise and recruit.
Yes.
This judgment was delivered sometime in February or April in 2006. That is Uma Devi case.
My lord.
After Uma Devi case, you should have stopped them from work. Without doing it, you are continuing in employment.
My lord.
That is why I don't know to whom I refer to a decision.
But
You see the judgment of the Madras High Court in 1986, TNLJ,
My lord.
page 153.
TNLG page 1.
Is a class 4 employee. Take the judgment of the Madras High Court. 1986. Tamil Nadu Law Notes Journal, page 153. I think this is a FCA case.
My lord.
The Supreme Court, the Madras High Court says, don't remove them from employment. You remove the person who have appointed them. And you are given a go back to the Supreme Court case. No, you cannot shed crocodile tears.
My lord, my lord,
Not correct.
there is
See,
another Honorable Supreme Court judgment, my lord, which may help our case also, my lord.
There are judgments after Uma Devi also, my lord, very recent ones also.
There are judgments
That also I
prior to that also, my
file
lord.
an affidavit.
file an affidavit, we'll see.
My lord.
Then we have to pass remark. Criticize the act of the respondent in the order. Only then they will not do it. See, every year vacancy will have to be identified
Yes.
and filled up, which has not been done.
My lord will,
That is the problem.
my lord will kindly,
You allow them to continue in service.
no, my lord will kindly appreciate. This is not a sanctioned post. This is not a vacancy per se, my lord. This is no, there is no vacancy
I'll
per
give
se,
you a number of judgment in service law.
my lord.
The factum that the person is allowed to continue for years to go to require a sanctioned post. Not correct. Ask the respondent to treat the person as a person. The employees are not commodities. You can't have the hire and fire policy. You say it's a misconduct. I'll be the first person to say send them out. More so if it's a breach of trust and misappropriation, I'll say doors.
My lord.
Show the doors. With regard to other conduct, if it is a service law, we have to apply the 8 conditions given by the Supreme Court. If it fits in to modify the punishment. If it's a labor law, 11A will come, will modify the punishment and give the appropriate relief.
My lord.
But not this way for 30 years. Will you accept? I'm not asking the government, I'm asking you in person.
My lord.
If your child, if your son or daughter is allowed to continue for 30 years, will you tolerate? You step into the shoes. Generally, it says that lawyers should not step into the shoes of the client.
My lord.
Agree. But lawyers should step into the shoes of the litigant to know the pains and sufferings.
My lord. My lord is correct.
Anyhow, we'll see the next hearing.
My lord.
Post. Today we are on, this is February, March. We are on 6th, 20th.
My lord.
Somewhere, check the number of cases depending on during that week. 18, 19, 20, 21. Monday to Thursday.
If you can file in advance, my lord, we can conclude our
Of course, I'll be filing in advance.
Copy. No.
Lord, otherwise I will not be able to file it, my lord, unless I serve a copy.
You cannot, this is not correct. See, government should be a model employer. Yes.
Obliged.
Second call, item number 1.
Obligation.
Yes, sir.
So, my lord, we are back with my lord's suggestion that we would obtain that instruction as regards, my lord, that conferment of penalty on us. My lord, on the last day, they have submitted a document stating that we will be reinstated in service and that only part of the increment would be withheld. My lord.
Yeah.
So, my lord,
Three increments without cumulative effect.
yes, correctly, my lord. Correctly, my lord. So, my lord, here, my lord, if your lordship has perused my writ petition, there are 2 prayers, my lord. One is that, my lord, the quashing of the proceeding, which we will not be pressing.
The writ petition,
Other part is, my lord,
before a single judge, you can't press it.
yes, my lord, that part of the prayer where we say that the proceedings should be quashed, my lord, we say that let them conclude within a time frame for the last opportunity. they will be concluding. And that part, other part of my prayer was that, my lord, that the salary and increment which was passed by the honorable cat and was not interfered by the division bench of my lords.
All those things you will be entitled to, sir. All those things
Yes,
you will
Lord.
be entitled to. You will be deprived
Lord.
only 3 increments for a period of 3 years. Otherwise,
So-
see, if it is with a cumulative effect, your increment, postponement of salary, everything, fixation will be postponed. The process will be losing pension, gratuity, everything will be lesser.
Yes, my lord. My lord, as regard, my lord, that part of the order where the division bench says, my lord, that the applicant may be reinstated with immediate effect with all consequential benefits. My lord, this part was never stated. So, my lord, that part of from the date when I was reinstated till today, my lord, my consequential benefits has been withheld by them without any rhymes and reasons. So therefore, I pray, my lord, that
Sir, we will ask them to give all the benefit.
Maybe.
For the misconduct, you will be imposed with a punishment. All
Yes.
consequential benefits, you will get it. We will
Yes,
make it
my lord.
very clear in
And
the order.
yes, my lord. And that part only, my lord, that let them conclude within a time frame because my entire
What do you
case
mean we
was
conclude? We are concluding, sir.
my lord, that on my lord, if I may, my lord,
Suppose they impose the dismissal, what will happen?
my lord, in that regard, I have a
Ajit,
small
you've got
submission that
another
is
2
up to
months
my
afternoon
lord.
service.
My lord, only that part of my prayer where I say that they might conclude my proceedings because, my lord, my case was hinging on a single point that it was never willful. Well, if they give a reasoned decision on the count that it was willful, because, my lord, if I may submit, well, I'll just take hardly 2 minutes to satisfy my lord why it was not willful. Rule specifically 25(2) says the absence has to be willful in order to bring me within the ambit of the CCS rules. I say that mine was not willful because I went before the Agra hospital. In turn, they made a verification with the authorities, wherein the authorities themselves say that the treatment which I have taken was very correct and that was the only treatment I would have availed. Now, my lord, when I avail, I have to again get a certificate of fitness. Well, I could only obtain when the authority gives me a certificate that you are fit to join. The authorities very well gave them a verification, which they never brought it on record. So, my lord, I say that when I was not given a fitness certificate, I could not join. And that delay was for 373 days. Entirely, I was with the authorities
Sir,
at
according to
Agra.
you, do you mean to say that there should not be any punishment?
My lord, let them conclude with the reasons, decisions
Sir,
that it was willful.
please.
My lord, I get an
Sir,
opportunity
we are
to challenge
asking a
it before
specific
my-
question. We are asking a specific,
Correct.
we want a specific answer. Do you mean to say that for a misconduct, no punishment should be imposed?
My lord, in that regard, my lord, I have to just say that, my lord, if they give this conclusion, because the entire proceeding on the earlier occasion was dismissed on the count that it was vitiated, and the absence was not willful because, my lord, they come up with a conclusion that I admitted the charge. Rather, the division bench held the charge which I have admitted is also not on record. My lord, even that was countered. My lord, if I may take my lord to that specific part of the judgment where it says that even that part was not true.
Yes.
Yes, my lord.
Where is the?
Your lordship, yes. Lordship may come at page number 34 of my writ petition of before the single bench, my lord.
30?
34. 34. Annexed to this is the division bench judgment, my lord.
34 are there. But see, the writ petition filed directly will be dismissed.
My lord.
The writ petition filed directly before the single judge will be dismissed. Your relief is only before the Central Administrative Tribunal, not before the single judge. The writ petition now we have called for the records with regard to the writ petition.
Correct, my lord.
You have to go only before the Central Administrative Tribunal. Pre-service condition, present service condition, future service condition, that is after retirement, everything will be governed only by the tribunal alone is entitled to and they are entitled to get relief by filing an application under section 19 of the Administrative Tribunal Act 1985. High Court cannot entertain the writ petition. So the writ petition will go. Now you argue the writ appeal, the other writ petition.
My lord, that writ petition, my lord, I would say, my lord, L. Chandra Kumar is quite clear. My lord, the high courts equally have the parallel jurisdiction
Oh,
under
oh.
226
You want to
authorities. My lord.
get my
L.
phone. Get my phone.
L. Chandra Kumar is quite clear on that, my lord. And I before the Assam rifles, my lord, there are several matters, my lord, before the single judge we had been contesting on this grounds, my lord.
Maybe that is wrong. I can't follow that.
My lord.
I can't follow that. So I think I've sent you 2 judgments.
My lord. Since, my lord, there was an order again from my division bench of my lord.
This one, right? 2002 to SCC 314. The other one is 2021. Delhi 2086. Yes. Yes, what is your case? You argue. What do you want to say yesterday? I'm
Only
sorry.
that part of my lord.
I am extremely sorry. I am not going to agree with you. That's all. Yes. Because in the one case where you are not using your good offices, you are not prudent to utilize our offer. Our suggestion. That's all.
Lord, only that was my instruction, Lord. If I were
No, we are
placed
not
it
saying
on a
anything.
system that
We are not saying anything. I think your client is not interested in settling the matter. That is all. She must be employed somewhere and she think that it's a bounty. She may think that if we succeed, she'll get the entire amount. It's a lottery.
No, my lord, I just think that, my lord, that proceedings would be concluded, my lord. Only that part of increment I had to pay, my lord. That is what, my lord, I could mean, my lord.
Suppose,
That
sir, you
part
must
of-
suppose they impose the dismissal, what will happen?
That is what, my lord, truly correct, my lord. Your lordship has rightly appreciated on that count, my lord. So, my lord, I leave it to my lords then, my lord. I have nothing to
To
say.
take the judgment, sir.
My lord,
Janaki Raman has some judgment, regular, where there are 8 conditions laid by the Supreme Court. They're shockingly disproportionate. Take the judgment. It's there in my notebook. We'll pause orders.
Well, as far as we are concerned, we have agreed to reduce it to with
We
only
have 3 increments without cumulative effect.
man.
We'll record your suggestion and pass it. Yes.
This one, as my lord is pleased, my lord, your lordship may kindly
Yes. We'll
consider
say
that
we'll
part.
impose the punishment, we'll end, but you must give all the benefits
Yes, my lord.
approved to her, arising out of.
My lord, he is in service, my lord.
Yes.
He is in service.
She
Yes.
is in service.
Man.
Yes, sir. In service.
What is your petition number? One is 28 of 24 years filed. You filed, you know?
20.
My lord, one is filed by them, my lord.
Oh, that's one by you. What's your number?
1.
28 of 24, my lord.
You filed.
My lord.
Yes, by the state, by the Union of India.
And they have filed WPC number 1 of 24.
One of?
1 of 24.
What are all the punishments in your service regulation. Suppose this punishment is not there, we cannot impose.
It is there, my lord.
Is there?
My lord.
Stoppage of increment?
My lord, he will be governed by CCS rules, my lord.
Huh?
He is a civilian employee in Assam Rifles, my lord. He will be governed by the CCS rules.
CCS rules.
My lord.
Chief.
Which rule? Show that rule.
I'm,
Don't have.
I'm not carrying the CCS rules. I'm sorry, my lord.
Well, it's known as TCS rules of 1972, my lord.
Yes, CCS rules.
Yes, my lord. Leave rules of 1972, my lord.
Leave rules.
Central Civilian Service. Yes.
Procedure for imposing
Leave.
major penalties, procedure for imposing minor penalties.
Under 25(1). Clarification, interpretation, penalty under CCA rules 1965. Reduction of board from scale to 11 for pictures. 11 to 11 to 11 to 11 4.
Chaturvedi வந்து 3 judges. One more, இல்லையா?
Clarification into the department sections to withholding promotion recovery reduction withholding of potential withholding recovery government.
No, the
Withholding of If I may please, Lord. But this is a clarification and interpretation of penalties under CCS rules 1965. Under column number 4, it's withholding of increments and pay, my lord. That is what, my lord, I could get. It comes within minor penalties, subclause 4, withholding of increments of pay. This is the penalty which the government can.
Rule 11.4.
My lord, it reads as,
Rule 11.4.
yes, my lord.
Rule 11.4.
11.4, my lords.
Rule 11.4, 1 minute. We'll take the rule 11.4.
Minor penalties. If I may read, my lord, the following penalties are prescribed in Rule 11 of the CCS Rule
That's why
1965.
yes, minor penalties.
Yes. The following penalties may good for sufficient reasons and herein provided be imposed on a government.
Stage of time scale by one stage for a period of say not exceeding without cumulative effect, not adversely affecting pension. So this will come under this will come under 11.3a. Reduction to a lower stage in time scale of pay by one stage for a period not exceeding 3 years without cumulative effect, not adversely affecting his pension.
Yes, my lord. Correctly, my lord. 3A, my lord. 3A.
This punishment.
Yes, my lord.
This punishment.
As my lord.
We have proposed 11.4, my lord.
Huh?
We have proposed 11.4, my lord.
11.4. Without 11.4.
They have proposed.
Recovery of increments of pay.
My lord, for 3 years, my lord.
But no year is mentioned.
Yeah, yes is not mentioned, my lord.
You want to impose a 4.
4, my lord.
Whatever it is.
For 3 years.
11-4. See, if they impose,
Yes, my lord.
11-3,
Yes, my lord.
your pay scale will come down.
Yes, ma'am.
Correctly, my lord. Correctly, my lord. Absolutely correct.
Then you will lose the benefit. If they are going to impose without of increments of pay, 3 years
Yes, my lord.
increment alone will be withdrawn.
Yes.
Nothing else.
Yes.
On the 4th year,
Yes.
ultimately the original pay will be restored.
Yes, my lord.
Yes.
Right.
If this is imposed, original pay cannot be restored.
Ma'am.
Rightly, my lord. Absolutely correct. Agree, my lord.
Yeah, we will pass an order. It says
Yes,
that you are
ma'am.
not considered. We will pass orders.
Maybe.
If you are considering it very good for us, if your client is there, if he is agreeable, you can give a quietus to the matter, Mr. What's your name, Mr. Harish? Huh?
Yes, my lord. Harish Vitala, my lord.
Ah. If your client is agreeable, we can give a quietus to the matter.
My lord, he has to agree, my lord, as has followed by
That's
my
a problem.
lord. That is a very, yes, my lord.
Correct.
My lord, it's better, my lord, we are putting an end to a litigation, my lord.
One second. 2015 2 ACC 610 is a judgment. Court shall not go into the proportionality of the punishment unless it shocks its conscience. I think it must be clause number 8. A judgment.
My lord, in fact, he is habitual offender, my lord. We have stated that out of his entire service, he is on leave only, my lord. He is on leave for a substantial period, my lord. Not only this time, my lord, in the past, once he goes home, my lord, he never comes back in time. And that is why the major.
Otherwise, the matter will have to go back before you and you will have to conduct the inquiry.
My lord,
Procedure has not been followed.
my lord, we are agreeable to that, my lord. Your lordship, we will give the quietus to the entire matter.
Sir, you must also take into account the family circumstances. She says that daughter was mentally unwell and all those things, which you have not disputed it.
So that is why, my lord, we have reduced. We are imposing only a minor penalty.
See, the reason for giving minor penalty and major penalty in the rules or regulation is to ensure that the proportionate punishment is given.
Right. So we are rectifying that, my lord. We are giving minor.
It's a case of, see, if it's a case of misappropriation, breach of trust, send them out.
Right.
They should not be allowed to be in service. In so far as other abusive language, absence and all those things,
But only because he is not on soldier duty, my lord. In soldier duty, absence is a very serious offence, my lord. But he is only a clerk, my lord. So that is why we have taken.
Typist, my lord. In fact, a typist, my lord.
Advocate General only read the employment. Nothing should not be like a pendulum. Is it not? There was a judgment of Madras High Court with regard to grant of maternity benefit.
Well, as Assam Rifle, 70,000 strength, my lord.
70,000?
70,000, 70, my lord. They have to maintain discipline also, my lord. That is
70,000?
forces, my lord.
Posts.
My lord. 70,000 soldiers, my lord, in Assam Rifle.
70,000, no, 70,000 only I was able to understand.
No, my lord, in Assam Rifle, there are 70,000 soldiers, my lord.
Soldiers.
My lord. So we have to maintain discipline also, my lord.
Very right. See, if it is a soldier,
My lord.
definitely no relief. But he is not a soldier.
He is a typist.
A typist.
So, my lord, we have equally a judgment of the Madras High Court, my lord, where it states, my lord, that the Honorable Supreme Court reported in this, had once a direction is issued by a competent court, it has to be obeyed and implemented without any reservation. In paragraph 31, it is held thus. We are of the considered opinion that once a direction is issued by a competent court, it has to be obeyed and implemented without any reservation. If an order passed by a court of law is not complied with or is ignored, there will be an end of rule of law. If a party against whom such order is made has grievance, the only remedy available to him is to challenge the order by taking appropriate proceedings known to law. But cannot
The rants there, my lord.
Something wrong.
made in
Sir, you must understand that even in contempt also, the Supreme Court has held that we should be very slow in asking the person to appear. That is the reason the judgment.
Process pass, appropriate order.
Yes, orders reserved.
Deeply.
My lord, if I may, my lord, item number 6, my lord, with regard to the coal matter, my lord, wherein I have made a submission that the matter, the full bench matter will be coming on the 12th, my lord. We have verified, my lord, the matter is coming on the 14th of March, my lord, not 12th, my lord. If that mistake may be corrected, my lord, in the order. 14 March, my lord, not 12th March.
Change the date, it's 14 March.
I'm obliged, lordship.
Right.
Within 190 days.
Coming up for admission? So is it coming up for admission?
My
Delay control. What is the issue, sir?
But here, my lord,
So whether they are entitled to parity retrospectively,
my lord, my lord, my lord. And several issues have been
because you have given it from a future date.
My lord, here my basic issue, my lord, in Assam Rifles, my lord, the rank structure is like this, my lord. At the bottom is the rifleman, my lord.
What of?
Rifleman is at the bottom. Thereafter, my lord, the rank of Havaldar. Then the rank of Naib Subedar, my lord. Now, the learned single judge has recorded in the order itself, my lord, that in CRPF, an upgradation, my lord, they are to be given superintendent, Havaldar's post, my lord. But the learned single judge, while recording that, my lord, has directed us to give him Naib Subedar, my lord, which is one rank higher than the Havaldar, my lord. This is not the case, my lord. I'll just point.
Can you take notice?
My lord?
Take notice. Submit notice.
My lord, here this issue is already settled by the division bench, my lord.
We'll hear, but you're only coming up for admission.
My lord.
Please give the list of dates and also the tree.
My lord.
Tree in the sense, the lower post,
My lord.
then the feeder category above that,
My lord.
which is a feeder category for the next post,
My
like that.
I'll prepare
the tree.
My lord. I have already, my lord, submitted two compilations. One, the series of judgment passed by this honorable division bench of this honorable court and single bench, as well as the order implemented by them.
Oh, implemented.
Already implemented in the almost all. And even division bench has already allowed 15 sets of technical trade. They are left out 2 or 3 trade. They are left out trade. We deny that, my lord. Well, I'll argument. And division bench has already settled.
Cases. What's the matter? First week in the month of April. Give the date. Yes, April.
BP.
Only case.
Published.
Yes.
From the minutes, item number 1.
Single.
Item number 1.
Today we have lots of matters. Yes. Yes.
I have prepared a small list of dates, my lord, for your lord's convenience, my lord.
Same one. It's already there. Already there.
But the sum of the case, my lord, he was serving Assam Rifles, my lord. He went on deputation to Sardar Patel National Police Academy in Hyderabad, my lord. And thereafter, he didn't want to come back. He wanted extension of his deputation, which we denied, my lord. And even thereafter, he did not come and join, my lord. So ultimately, after waiting for a certain period of time, my lord, we have discharged him from service. In the meantime, he went to Andhra Pradesh High Court, my lord. And my lord, from the list of sequence of events, if I can place.
He went to Andhra Pradesh High Court.
My lord.
He approached Andhra Pradesh High Court.
My lord. He approached simultaneously Andhra Pradesh High Court also and this honorable court also, my lord.
He was serving there.
Right now, he is not serving anywhere, my lord.
My lord, here there is no, my lord, on the previous round of litigation, my lord, they have declared the petitioner as a deserter, my lord. The learned single judge of Meghalaya High Court, my lord, by judgment and order, my lord, has stated that to conduct a fresh inquiry with regards to the absence. Why absence, my lord?
Absence.
My lord. My lord. The pursuant to that, my lord, the petitioner, my lord, had attended the court of inquiry, the issuance of summon. They have issued and joined the 13th Assam Rifle, where the court of inquiry was held. Thereafter, the court of inquiry was not concluded, nothing was given. The petitioner was told that you will be communicated by post, my lord. The petitioner left, my lord. And then, my lord, the respondent there is no dismissal order as of now, my lord. The respondent.
What is the prayer you are seeking for?
My lord, we are seeking for direction to the respondent to allow me to join the service, my lord.
Here?
Here, my lord.
After how many years?
My lord,
what is your age?
Age is, my lord, approximately.
No, you should have stated in your affidavit. You should have stated in your affidavit. Your name is Ramu.
Mal.
You're 39 years in 2011.
Mal.
40, 50 years now.
Mal.
Yes. What is the writ petition you filed before the Andhra Pradesh High Court?
My lord, there we sought for that extension of the time, extension of the period, my lord, and also, my lord, with regards to for issuance of the movement order, my lord. Without the movement order, I could not be able to join the service, my lord, at 13th Assam Rifle.
What happened to your regularization?
My lord,
because there is an order by the Andhra Pradesh High Court that your services will have to be. See, now you have gone on deputation.
My lord.
Correct?
My lord.
Who is the fourth respondent?
My lord, that was my lord.
Sardar Vallabhbhai
Patel, my lord.
You have already been relieved by the second respondent. Any movement register was given by the fourth respondent?
My lord, no, my lord.
Then, see, unless they give the movement register record, they will not be in a position to take you in service.
My lord. Even
Your case is that you want to be observed in Assam, in the at Hyderabad,
my lord,
Sardar Vallabhbhai Police Academy.
my lord.
That's your case. That means you are not interested.
No, my lord. We are interested. We have sought for the extension along with the NOC for observation, my lord. We are interested, my lord. The respondent authority here, the Assam Rifle had denied that no NOC cannot be.
See, after the completion of 3 years of service in the fourth respondent, the petitioner submitted representation to observe him on regular basis in the fourth respondent academy.
My lord.
What does it mean?
My
You are
lord.
not interested in coming back. Nothing wrong in say, they are saying that you are etc.
My lord, that desertion, my lord, part, my lord. This Honorable High Court, my lord, by judgment on order dated 15th, my lord, has waived that and directed the respondent to convene a fresh court of inquiry. That desertion order was set aside, my lord.
Where is that?
My lord, that is at
Ten 2015.
my lord.
To conduct the inquiry and complete the proceedings. See, you are not taken a plea that he doesn't want to join Assam Rifles and he has already joined Sardar Vallabhbhai Patel Police Academy. And you should have given him the no objection letter.
My
For him to absorb.
lord, even the academy doesn't want him, my lord. That is why he went to the Andhra Pradesh High Court.
Suppose you have relieved
My lord.
him. If the police academy doesn't want, then his remedy is only to agitate because they already relieved him at his request. Is it not?
My lord, that is true, my lord. But when he approached
So
the,
then he cannot have any right over you at all.
my lord.
So you kept quiet.
My lord, when he approached the Andhra Pradesh High Court, my lord, Andhra Pradesh High Court said that he has no right to insist on reputation to or absorption to the academy, my lord.
Whatever it is, you should have given one letter The trouble would have ended there itself. Is he working now? No.
No, man. Since he's out from our service since 2008, my lord. 16 years.
8, now 40, 50 years old. Then you will have to pay him subsistence allowance and conduct the inquiry.
They were kept silent, my lord.
Huh?
No inquiry. The petitioner went on, joined the service, my lord.
So,
Participated also in the.
you want salary.
My lord, about 10 years of service he has rendered, my lord.
So,
And
for
no-
10 years you would have got salary.
My lord,
For
no-
services rendered, you have not been paid.
my lord, there is no dismissal order or as on
No,
record.
sir. There is an order that you have been deserted.
Desertion
That
order.
has been set aside by the High Court.
My lord.
Correct?
Mal.
And a fresh inquiry was directed to be ordered.
Mal.
So don't say that there is no order of dismissal at all. There is an order deserting. Now you are deemed to be in service. Now let them place you under suspension, conduct the inquiry.
My lord.
What is it, sir?
My lord, lordship kindly comes to page 3 of my synopsis, my lord.
Page number?
Page number 3 of my,
List of events.
my lord.
Huh.
My lord, after this honorable court set aside, my lord, we issue fresh summons, my lord, on 10/6/2015, my lord, to him. Now, immediately thereafter, my lord, he goes and files WP in Andhra Pradesh High Court, my lord. My lord, the writ petition in Andhra Pradesh High Court was allowed, my lord, in directing the academy to issue movement order to him, my lord. We filed an appeal before the division bench of Andhra Pradesh High Court, my lord. And division bench of Andhra Pradesh High Court has set aside the learned single judge's order, my lord.
We are not concerned about Andhra Pradesh. Only for the narration of incident, only narration of facts only that is relevant.
My lord.
Now he has come back.
My lord.
And there is an order of Meghalaya Court for him to conduct the inquiry.
So we'll complete the inquiry, my lord.
To conduct the inquiry.
My lord. My lord, as far as subsistence allowance, because he has been working in academy also during
No.
such period of time, my lord.
We are not talking about the past.
My lord.
Today you have to place him under suspension or and conduct the inquiry.
My lord.
Or you have to pay him wages from today and conduct the inquiry.
My lord. My lord. We'll do that, my lord.
Yesterday we took out one judgment. Where is the 83 judgment? Chandravan case? That's the case, no subsistence allowance were there. And the person was offered 1 rupee subsistence allowance. Supreme Court came down heavily in Chandravan 1983. Supreme Court.
My lord. We'll do that.
Otherwise your order will be interfered with
My lord.
on the ground of non-payment of subsistence allowance. You have to place him on the suspension, you proceed with the inquiry.
But he complicated the matter so much, my lord, by filing writ petitions there in Andhra Pradesh High Court, filing here, my lord, parallelly.
I am not going to say whether he is entitled to back wages, other allowance, etc. Everything is left open.
My lord.
I am going to say that pursuant to the orders of this court, the deserter order issued has been interfered with.
My lord.
And you have initiated the disciplinary proceeding which you have not concluded.
My lord.
Sir, the petitioner, Chandraban. Don't.
I know, sir, because we pick.
It's 83, no? Yes. 1983, 3 SEC, 387. was paid subsistence allowance, then rule doesn't permit. It says, if further contends that the reduction of the subsistence allowance to ₹1 per month to a civil servant, which is prohibited from engaging himself in any other avocation during the period of suspension, contravene even Article 21 of the Constitution of India. The petitioner was appointed as a constable driver in Assam Rifles, Shillong, Meghalaya state. Thereafter, he was deputed to Sardar Vallabhbhai Patel National Police Academy, Rangareddy district, Andhra Pradesh. After completion of 3 years of service in the police academy, the petitioner made a representation to observe him on regular basis in the academy. The academy had sought for the consent to the Assam Rifles to extend the tenure of deputation and to issue no objection certificate. It is the case of the petitioner that Assam Rifles declined to grant no objection certificate. Questioning the action of the Assam Rifles in non-grant of no objection certificate, the petitioner filed WP 21144 of 2009, seeking for a direction to continue him in the fourth respondent academy. Continue him in the academy. There was an interim order passed by the Andhra Pradesh High Court on 8/4/2010, which enabled the petitioner to continue in service, which was vacated in WVMP 980 of 2010. Challenging the vacation order, the petitioner filed writ appeal 717 of 2010 before the Andhra Pradesh High Court, and the division will take up the writ appeal and writ petition together and passed the following order. Page number 9 there is a mark on it, red. So it is there in red, marked in red. Since the petitioner was permitted to give a representation, the representation that was made on 8/12/2010 was considered and request was rejected. Yet another writ petition was filed by the petitioner before the Andhra Pradesh High Court, being WP 7646 of 2011. And the court passed the following order. The first one is marked as A, this one is marked as B. As the petitioner lost the case before the single judge, he approached the division bench by filing writ appeal 731 of 2011, and the writ appeal was also dismissed on 19/9/2011. According to the petitioner, the Academy had issued, Academy has informed the petitioner, according to the petitioner, the Academy has informed him that while proceedings dated 14/11/2011, the service book, LPC, and other documents have already been dispatched to the parent organization, namely the Assam Rifles, who is the respondent herein, and that writ petitioner was no longer in the rules of the Academy. Challenging that order, another writ petition was filed wherein it has been stated that the petitioner was not paid a salary from 9/10/2009 by the Academy, and that the Academy shall pay the entire wages from that date. Full stop. It was stated by the respondent Academy before the Andhra Pradesh High Court, don't say respondent, stated by the Police Academy before the Andhra Pradesh High Court, that the Assam Rifles have not given no objection certificate for further continuation of the writ petitioner in the Academy, and that the petitioner has failed in several attempts in seeking relief before this court, before the Andhra Pradesh High Court, and that the petitioner would not be entitled to any relief. The writ petition 31563 of 2011 filed was also disposed of by the Andhra Pradesh High Court with the following directions, which is page number C, which is marked as C. Copy that. Full stop. The Assam Rifles were directed to consider the case of the petitioner's regularization of the services from 9/10/2009 in accordance with law. After the orders of the Andhra Pradesh High Court, it is stated by the petitioner that the representation given by the petitioner was rejected on 31/1/2011, which resulted not this one. That we have already noted. Remove the sentence. The case of the petitioner was that, in spite of the orders of the Andhra Pradesh High Court, the petitioner was not put back in service and granted relief. And that he has been asked to appear for an inquiry and there was no inquiry conducted at all. The case of the respondent Assam Rifles herein was that the facts narrated by the petitioner Supra is not in dispute. Both of you sit. Both of you sit. If you have any doubt, you will ask. You would submit that the petitioner did not evince any interest in joining Assam Rifles and wanted to continue in the police academy at Andhra Pradesh. Even after the orders of the Andhra Pradesh High Court dated 14/11/2011 in WP 31563 of 2011 mentioned Supra by the petitioner, the petitioner was asked to come for work and that the petitioner did not join service after seeking leave, which was initially granted. Since the petitioner did not join the duty, he was declared as deserter and the name was struck off from the rolls of Assam Rifles. This resulted in the petitioner in filing a first writ petition before the writ petition before this court, being WP 72 of 2013. On 5/2015, the court passed an order that the petitioner was not given any opportunity before passing an order of desertion dated 28/10/2010 and interfered with the same and directed the Assam Rifles to conduct the inquiry. According to the respondent, a fresh inquiry notice dated 10/6/2015 was issued. No, fresh inquiry was fixed on 10/6/2015, while communication dated 10/6/2015. In another WP filed by the petitioner, being 31563 of 2018, the court directed the issuance of movement order, which was stayed in writ appeal 1562 of 2018 on 3/12/2018. That is the order of the 11th single judge dated 29/8/2018 was stayed. Interim order stayed. Finally, the division bench has allowed the writ appeal 1562 of 2018 and set aside the order of the 11th single judge. Which means that the petitioner is not entitled to seek for a movement order. The counsel appearing with the respondent fairly stated that the inquiry has not been completed and the petitioner is not evincing any interest to join duty. There is no objection in conducting inquiry and complete the proceeding at the earliest point of time. Since the petitioner is a rifleman, GD, who joined the services on 3/7/1994, he is expected to be fit for duty and should be regular. He cannot blow hot and cold. That is, namely, after joining the services, went on deputation to academy and wanted to continue there. For various reasons, the petitioner services could not be continued at academy, and the court observed that there was no movement order issue, no objection certificate issue. Full stop. The respondent submitted that the petitioner has not joined duty in spite of asking him to report for work. Though he has been initially called as a deserter, which was interfered with the scope, the petitioner has to cooperate in the inquiry. He would further submit that since he has not reported for work, he is not entitled to any wages on the ground of no work, no pay. Full stop. Since the order of this court dated 5/5/2015 in WP 72 of 2013 has attained finality and binding on parties, petitioner has no right to demand anything except participating in the inquiry. There is a dispute with regard to reporting of work, and this court is not inclined to make any comment on that and to make any observation as to whether the petitioner would be entitled to wages from so and so date as per the orders of the Andhra Pradesh High Court. We direct, the payment of wages and other benefits will depend upon the outcome of the order that may be passed based on the inquiry that may be conducted. It is open to the petitioner, open to the respondent, either to reinstate him and conduct the inquiry or place him under suspension and conduct the inquiry. Full stop. It is for the respondent rifles to take a decision, Assam rifle to take a decision. The petitioner is expected to cooperate with the inquiry. The respondent is directed to conduct an inquiry on day-to-day basis without adjourning the matter beyond 7 working days at any point of time and bring the issue to a logical conclusion within a period of 3 months, 4 months, 5 months.
4 months would do it.
Within a period of 4 months from the date of registry of the order, preferably on or before 15th August 2024. The petitioner is expected to cooperate and not to seek any adjournment on any score. After the decision, after the inquiry proceedings are over, depending upon the order that may be passed by the decision authority, the other relief based on the order of the decision authority or the appellate authority will follow if it has attained finality.
Well,
Writ petition is the post off. You take the Chandraban judgment and inform your people.
well,
No, that is for the measure. Substance are not to be paid as per the rules. Then we can add it, appropriate.
a small correction. In the beginning, he's come as a driver, my lord. He was not a driver. He was a constable, rifleman. GD driver.
Constable, huh?
Rifleman. He was a rifleman.
Rifleman. So we have stated only rifleman. Rifleman na
In the
put
beginning, he's come as a driver.
Oh, sorry, rifleman. Huh? You give the paper here.
In the first sentence, it is come
Oh,
as a
1 minute,
driver.
1 minute. I would have seen somewhere. Otherwise, I would not have dictated like that.
That's what I was wondering.
1 minute, 1 minute. Subsequently, I have stated that it is a
Driver.
in the Andhra Pradesh order, it has been stated that the petitioner was initially was appointed as a constable driver. So that is why
Well,
what is there incorporated. You say they joined as a rifleman, GD, bar GD.
My lord, pursuant to the notice, my lord, the petitioner has joined the Assam Rifle, my lord. He has joined the
Where he has
no
joined?
question of joining, my lord.
13th Assam Rifle.
Huh?
The summon was issued to the with regards to the court of inquiry, my lord. He has joined the Assam Rifle, my lord.
Where he has joined?
13th Assam Rifle, my lord.
He is working now.
No, my lord. After that, the petitioner was said that you have to leave we will communicate the order to you with the court of
That or not, we do not know. This is a dispute question of fact.
That's not required.
Either for them to reinstate you and proceed with inquiry,
Well,
or place you under suspension. The discretion is there. We cannot say anything. You place him under. We can't pass an order, place him under suspension.
well,
And Supreme Court in another case has also said, don't keep a person under suspension for years together. Put him back
well,
unless a serious offence. And in another case, Supreme Court said if a person is facing a criminal case for an identical charge, you wait for 1 year. If the charge sheet is not filed, you proceed with the inquiry, even if the charges are identical.
only for 1 year.
Huh?
Only for 1 year.
Only for, you can wait only for 1 year. They have taken, we have passed orders at Madurai. Huh? They have to have one other judgment is also there.
Well,
There are 2 judgments in the Supreme Court.
I'll go through.
I think 13, 14 or 14, 15. Somewhere. 18. Yes.
Item number 2 and 3.
The 2 and 3 are identical, more or less, my lord. He was discharged on the ground, my lord. That
Sir?
is discharged from Assam Rifles on the ground of alcohol dependence, my lord. Alcohol consumption, my lord.
ADS, my lord.
Alcohol dependence syndrome.
Syndrome.
Heavy dependence on alcohol, my lord.
Medical.
Medical, my lord. My lord, 2 and 3, I was praying for some accommodation today, my lord. Any day, my lord. Maybe tomorrow, day after tomorrow, or next week. my lord.
Even 18. Item 2 and 3. Which one? 12th.
12.
You finish the matter.
My lord.
Item number 4.
See, if you argue, I'll dictate all the orders in the open court.
Well,
Item number 4.
See, the division bench why I am reserving is, I don't want my brother to waste the time. At least he can do some other work.
well,
So when I'm free, I'll go and dictate the orders. That is the reason why I'm not dictating the big matters in the open court.
Well.
All matters.
well.
372. Yes.
May I please your lordship? May I please your lordship?
Shall we continue after lunch? Who are you?
Your Lordship, I'm for respondent number 5 and 6.
5 and 6, yes.
Yes, Your Lordship, conducting counsel is in between the meeting by association, and he's also the assistant
counsel.
The counsel for the private respondent, according to him, is in the midst of the meeting.
Midst of a meeting, huh? I know it's missing.
He's in the meeting in the midst of the
That is why, no, pronunciation is very, very difficult. Yes. Yes.
Your Lordship may kindly take up after lunch.
Yes.
Today, you want the matter today? Today or what?
What is the matter about?
Lordship, this is the case. The case where they claim that they have challenged one notification issued by the letter of the government, Your Lordship. When we say, Your Lordship, according to the.
So, what is the order of the challenge?
No, it's not a discharge, Your Lordship.
No, what is the order of the challenge?
Well, the issue here pertains to Milord's payment of salary to SSA teachers, Milords. The petitioners before Your Lordship.
So, discharge the work.
No. In this case, the present case,
they're not discharged, Milords. They're in service. They're not being paid their salaries.
So, for work rendered, you are not being paid, sir.
No, Your Lordship. So far, this case is concerned, Your Lordship.
In item 5,
whether the issue is to be determined whether under SSA, Your Lordship, whether the post of Hindi teacher is there or not, Your Lordship.
It is different. Now, having extracted work, how do you say that you can't pay wages? We must know.
No, in this case,
his case.
In this case, Your Lordship.
My Lord, item number 3, 4 and 5, item number 4, 5 and 6 are identical in nature. Here in this case, what happened, Lordship? The school of the petitioner was brought.
But anyway, he is seeking time. Otherwise, very easy to pass orders.
Very limited issue to be decided.
Brought under SSA in the year 2010, Lordship.
Limited issue.
Sir, if you argue, we will pass orders. You bring your friend, missing friend.
Yes, Lordship.
What to do?
So he's playing the second half, Lordship.
Yes,
at the end of the board, Milord. Have it at the end of the board.
Second half.
Second half.
Yes, Lordship.
This afternoon.
Yes, Lordship.
So we'll assemble at 2 o'clock. So not 2 o'clock. It will take 2:15. So I'll have to go home and come.
Milord, the second have some difficulties there, Milord.
Huh?
Second have some difficulties there, Milord.
For all.
No, not for me, Lordship.
Those who are going to go to other court, I will not prevent.
Milord.
Others I will hear the matter. You are held up a whole day in some other court.
Milord,
So what is the difficulty? You tell me.
some personal difficulty, Milord.
For you.
Yes, Milord.
So not for the entire bar. Then if you have a problem, then we'll adjourn the matter. We'll adjourn the matter. It's not a problem. Let it reach, we'll adjourn the matter.
Milord.
I will dismiss the case on merit. I will never dismiss the case for default. Unless the opportunity is. If you don't have a case on merit, I will dismiss. That's all. So let it reach.
Milord.
So you are available, you argue. If you are not available, adjourn the matter. Not a problem.
Very good.
Here, see, Matt, about out of 848 matters on 31st January, it was total number of cases pending was 848.
Lordship.
Single judge and division bench has disposed of 120 matters in February. So, if you give more opportunity, we will dispose of more cases. Now it has already, subsequent to filing is there, now it has increased to 841. But we are happy that the pendency is being reduced. And the purpose of keeping now 2013-14 matters is not going to help. From April, I will try to take up all the up to 23, 24. Almost all the service matter.
Yes.
And I will be sitting the whole day. Those who are available, they can argue. Those who are not available, will adjourn. See, you must understand, I want to inform the bar. One order is passed by Justice Ding Dong. Then I will have to sit with Justice Bhattacharya or Justice Thank You. If one person has recused, then I will have search for a person. So last week I sat with all the 3 persons apart from single sitting. So now it is going to be 3 bench and 1 single sitting. Unless there is a cooperation from the bar, then penalty will not be reduced. You are going to have a result. That's all. See, there is a horoscope called, you know, horoscope. It's a prediction.
Lord.
Once you is born, the time and date is taken and that horoscope is drawn. Similarly, when you tie a bundle, the bundle has also got a horoscope. Either you have a this side result or that side result. So you argue the matter.
Possible.
See, I find it, having, worked at Madras, sitting, it's 48 sitting judges around the clock. No work afternoon, I find it very difficult. Of course, I am reading all the acts and rules of the various communities. You got 4 tribal laws. I am reading it. But how long I can read? The reading, I have to apply it, Unless you argue, I can't apply. So we'll assemble at 2:15. See, those who are not ready, take an adjournment. It's not a problem. They give the date to you inform the court officer. The only thing is you must inform the other side. Inform the other side and take a date. Sir, don't post more than 10 cases a day. Ensure that, 10 cases a day, because the division bench is also there. So that I'll distribute my work and do the case. Today I never expected about 30 cases in the division bench. So those who are not ready, please, juniors, avail the opportunity, absence of senior, argue the matter. Yes.
Awesome. You have to arrange with the chief. You are appearing in 5 also? No, I am appearing on 4 and 6. You are in 4 and 6. I use the question. That's why I give you a thing. What to do? You are you can be there. Okay, sir. I'll finish it off. I have read both the files. They are very easy. Just please hold matter. 5 minute matter. I will not take more than 5 minutes. I'm going to